the next session. Next session is appointment of arbitrator. Now, from this session onwards, all the sessions are focused on the individual procedures. So, therefore, not to worry, whatever you have heard so far, they are just like an outline. From now onwards, you will see in-depth process. For example, this session is about appointment of arbitrator, wherein we will deal with the 360-degree view of the appointment of arbitrator process. Okay, therefore, attendees, you may find more and more engaged as well as interesting from now onwards. Okay, it will be kind of a real life arbitration process. Let me open my point. Hope it is visible, Madhu.
Yes, sir.
Okay, thank you. Okay, so in this session, we will see the process of appointment of arbitrator, conflict of interest in detail. If the arbitrator is not in compliance, then what is the remedy? I think somebody has opened their audio. Kindly mute, Madhu, everybody. Thank you. So we will also see challenging the appointment of arbitrator. So that also we will see. Okay. We have seen more than once arbitration is all about party autonomy. Parties, they decide many things. As rightly mentioned by my colleague in the previous session, the hallmark of arbitration is party autonomy, unlike the court process. And then next hallmark is arbitrator. He is the master of decision. He is the master of interpretation of the contract, and he is the master of the process. His decision is final and binding. It cannot be challenged. It cannot be appealed. It can be challenged, but it cannot be appealed. We will see what is the finer points. And then principles of natural justice. That is the important pillar of arbitration. An arbitrator cannot be a judge for his own dispute. It implies that he should be away from any kind of conflict of interest. It is as simple as that. Now we will see what is the difference between arbitrator and a judge of a court. In the arbitration process, the arbitrator is appointed or selected by the parties, often based on the expertise and the experience. My colleague, she mentioned that if it is a construction project, then ideally an engineer or techno-legal person can be an arbitrator, so that he will be able to adjudicate factually. That is how, people like us, we are techno-legal. We do the due diligence process. Whereas in the court, the judge is assigned by the court. So where the parties' inputs do not matter really. In the arbitration, resolving issues between the parties are confidential and private. Whereas, in court, it is a public procedure. Everybody knows. Also, unless otherwise agreed, arbitrator's decision is final and binding and cannot be appealed. Either party may appeal the court's decision in a litigation, in the court process. Especially in common law countries such as in India, every decision of a court will die and live 7 times. It has 7 chances of appeal, starting from district court up until Supreme Court. That is the main reason for the delays in the court process. Whereas in arbitration, it is not so. Even though it has courts interferences in the common law countries as well as in the civil law countries, the duration for arbitration is limited by law. A few more differences. Power of arbitrator is limited one, unlike the judge of a court. What is the difference in the powers? Arbitrator, he cannot issue any direction or order to a third party to the case. Suppose if there is a dispute between two parties, but a third person, he has some knowledge about it. Arbitrator, he cannot issue direction to the third party, whereas the court can do that. Also, interim orders. Before concluding the arbitration, interim order can be issued by the arbitrator, but only on the very limited grounds, such as protection of the subject matter, only the arbitrator, he can issue the interim orders. Also, no power is conferred upon the arbitral tribunal to enforce its order. So, arbitrator's mandate ends once he makes the arbitration award. Okay. After making the award, the enforcement is by the court only. So, these are the final points of the arbitrator versus the judge of the court. Okay. Okay. Now, what are the preconditions for the appointment of arbitrator? So, we all know that there should be a claim, and the claim should have been refused by the other party. The claim and the repudiation of claim, that is the first and the foremost requirement. Only with the claim, you cannot go to an arbitration. Okay, that you must know. If you are from a contracting company, if you have a claim against your employer, first you have to submit your claim to the employer, and he must refuse that claim. Okay, then only the claim will become a dispute. That is the starting point, okay, for the arbitration. Then only you can invoke the arbitration. That is the first prerequisite for the appointment of arbitrator. Okay, then there should be an arbitration clause in the contract. Then only you can invoke the arbitration. In some cases, what happens? Even if the contract doesn't have arbitration clause, the parties, they can create arbitration agreement later on. Separate arbitration agreement, and based on that, arbitration can be initiated. Okay, we have done many such cases, and my colleague, she will show you some live example, and she is talking about arbitration agreement in the next session. The party filing the application, he should be privy to the arbitration agreement. We all know in any contract, there will be two parties, isn't it? Issuing party, receiving party. In construction, it is employer and the contractor. So therefore, only these two people, either of these two people only can invoke the arbitration, not a third party. A subcontractor cannot invoke the arbitration between the contractor and the employer. Okay. Only the parties who are privy to the contract or the agreement, they can invoke the arbitration. Notice invoking the arbitration clause has been issued and received by the other party. Okay, that is very important. After that only arbitrator can be appointed. Pre-arbitral steps, what are they? If you look at your arbitration clause of your contract, there must be certain pre-arbitration steps such as negotiation, amicable settlement, arbitration, conciliation in certain jurisdiction. In India, up until the Mediation Act has been enacted, conciliation was very much prevalent. Even today, it is prevalent. Okay. So therefore, in such jurisdictions, you will find conciliation also. That is also a binding process. So coming back to here, if your arbitration clause has any pre-arbitral steps, it will be kind of multi-steps. First, if there is a dispute, parties, they should go for negotiation to arrive at an amicable settlement. If that fails, then they will go for conciliation. If that fails, then they can go for mediation. Again, if mediation is a non-starter, then they can go for arbitration. Okay. So this is the pre-arbitral steps. So before invoking the arbitration, pre-arbitral steps should have been completed or exhausted. Then only you can go for appointment of arbitrator. Okay. So these are the important requirements before appointing the arbitrator. Now we'll see what are the ways of appointing arbitrator. Of course, we have seen this is one of the important party autonomy, where the parties, they have the right of appointment of arbitrator, unlike the court process. Okay. So both the parties, they can sit together and they can agree who is their arbitrator, what should be his qualification, what should be his nationality, whatever they feel. And of course, in compliance with the arbitration clause. Suppose if one party invokes arbitration and he says that Mr. X, an engineer, will be the arbitrator. Or if he proposes 3 names, X, Y, Z, to the other side, and the other side he says, no, I don't agree any of these 3 names, then the parties, they have to go to court. They have to approach the court. And the court will appoint the arbitrator. Also, the parties, what they can do, they can approach arbitration institution, such as DIAC, ADGM, in UAE.
So sorry.
Yeah, please. Yes, Madhu?
Sir, your network is a bit slow. You may turn off the video.
Sorry?
Sir, you may turn off the video.
Okay. Is it okay now?
Yeah, now okay, sir. Seems your network is a bit slow.
Okay. Is it okay now?
Yes, sir. Please.
All right. Okay. Thank you. So should I go back, Madhu?
Not really, sir. Please.
Okay. Thank you. Right. Okay. So I've been talking about the ways of appointment of arbitrator. Okay. By parties' consent, of course. And they may approach the arbitration institution, such as DAAC, ADGM, SIAC, Singapore International Arbitration Center. And if it is in India, Delhi International Arbitration Center, India International Arbitration Center, IAAC. There are many arbitration centers around the world. Vienna International Arbitration Center, VIAC, So they can approach them. They will do the appointment of arbitrator from the empaneled arbitrator list. Okay. So, and then if the parties, they don't agree on the choice of arbitrator, then the court will appoint. upon the request by one party. And there is statutory arbitration in certain jurisdiction, such as common law countries. So statutory arbitration, the arbitrator will be holding the statutory position. Okay. And in certain arbitration agreement, the arbitrator will be named and agreed by the parties. Then it goes with the names. Also in public sector undertaking, especially in India, for the specialty projects such as railways and all, then subject matter experts, they should be the arbitrator. Airport construction, port construction, where the subject matter is a requirement, then they will specify in the arbitration clause. Okay, so these are the ways of appointing arbitrator. Party autonomy, we have seen, party, they can't decide what the number of arbitrators, whether it is single arbitrator or 3 arbitrators. Always it is on the single number, okay? And they can also decide the appointing process, whether they can appoint themselves or they can go to institution. Also, they can go for named arbitrator. Parties, they can decide what are the rules applicable to the arbitration. And of course, if no consent between them, then they can approach the court for the appointment of arbitrator. Okay, now we need to see the important element called letter of invocation. So this is the kickstart of the entire arbitration process. Letter of invocation should be issued by the suffering party, who is seeking the remedy. Of course, this is the important requirement for the appointment of arbitrator. Letter of invocation should have been issued and received by the other side. Okay, then only the arbitration, the starting date will be determined. The timeline, the arbitration timeline, it starts from there. We should be aware that whenever you are entering into an international arbitration, first you should check the arbitration law of the respective country. My colleague, she mentioned about different arbitration laws. As far as UAE is concerned, UAE federal law is there. And then free zones, they have their own arbitration laws. And she talked about Arbitration Act 1996 of UK. Of course, India, they have their own Arbitration Act. Okay. So, why I'm mentioning here, whenever you are entering into international arbitration, especially in your contracts, you please check whether it is domestic arbitration or international arbitration. If it is international arbitration, you must know whether time is fixed for the arbitration proceedings. If it is common law countries such as India, the arbitration proceeding is having the time limit by law. There is a time limit of 6 months plus 12 months. That is a mandatory time limit. Okay. So therefore, the time limit, it starts from the issuing and receiving of letter of invocation. That is the what you call a starting point for the calculation of the time period. Okay. And it is a legal requirement. It is a juridical starting point, you can say. Okay. So that is the importance of letter of invocation of arbitration. Okay. So the letter, it must be clearly and unambiguously show the intention of the sender for the appointment of an arbitrator. There shouldn't be any gray area. He shouldn't use may, I may go for, that should be clear and certain in terms. that should specify the contract under which the arbitration clause is being invoked. That should record compliance with the precondition for invocation of the arbitration clause. We have just seen about the pre-arbitral steps. First, they should have explained that the contract says about negotiation and mediation. We have already attempted that, and it was a non-starter. Therefore, now I am invoking the arbitration. Okay, so this is an arbitrator appointment form. Okay, I will show you the actual appointment letter also for your information. And then we have seen if the parties they do not agree the arbitrator appointment, then they approach the court. Okay. All right. So when the court is approached for appointment of arbitrator, the court will leave certain things to be decided by the arbitrator only. Court will not decide. Okay. What are the issues? The first thing about the arbitration clause itself. If there is anything gray area about the arbitration clause, court will not decide anything. Court will leave it to the arbitrator to decide. Also, the merits of the claims. When you go to the court for the appointment of arbitrator, the other side, they should not say there is no merit in the claim, and the court will not decide on that. Court will leave it to the arbitrator. Okay, these are the exclusive domains of the arbitrator. Court will only appoint the arbitrator. So therefore, the roles of the courts are very limited in nature. Okay, and now the arbitrator is appointed. But the other side, they feel that the arbitrator, he may have some conflict. Okay, there is some justifiable grounds which affects his independence or impartiality. Then they can challenge the appointment of arbitrator. So only there are two grounds. One, the first ground is there are justifiable grounds as to his independence or impartiality. Second, he doesn't have the qualifications agreed by the parties. Qualification is not specified by the Arbitration Act. But if the arbitration clause, it specifies certain qualification, then the arbitrator would be appointed only based on the qualifications specified by the arbitration clause. Nothing more, nothing less. On the contrary, if an arbitrator is appointed not in compliance with this requirement, then his appointment can be challenged. Okay. How they can challenge? If the other side, if they come to know about these two grounds, then within 15 days, he became aware of the constitution of arbitral tribunal, or he becomes aware of the circumstances what we discussed now, then immediately he should challenge. Where he can challenge? He can challenge only to the arbitrator only. Okay. So due regards to the qualifications and the disclosures. We have already seen the conflict of interest. That is the hallmark of arbitration. The arbitrator, he should never has any conflict of interest, either with the dispute or with the parties or with the counsels or with the outcome of the case. Okay. So parties before appointing arbitrator, he should seek a disclosure from the arbitrator. Okay, regarding his qualifications and his availability of time, about his disclosure regarding the conflict of interest. After that only they should appoint him. Okay, I will show you one such a disclosure which is in my case, for your information. Madhu, hope it is visible, Madhu.
Yes, sir, very much.
Okay. So this is the declaration. When we get appointed, we declare, like what is our experience, and do we have any conflict, about any business relationship or any other kind of relation between the parties, uh, as mentioned by my colleague in the previous session, that we must declare, okay? Or have we rendered any advice or services, to the party, to the proceedings? Or have you, in the past 3 years, been appointed as an arbitrator on 2 or more occasions by one parties or its affiliate of one of the parties? So these are the declarations we must do before accepting the appointment. Okay. Also, we must say, are there any facts which may affect your independence and impartiality? Do you have any past or present relationship with or interest on any of the parties? Do you have circumstances which are likely to affect our ability to devote sufficient time? That is very important. Otherwise, you have so many cases and you are left with very little time. Then how the arbitrator can devote his time? So he must declare that he is having sufficient time to devote in the current case. Okay. Then he has to accept his declaration. Okay. So this is a very, very important element of the arbitrator appointment. Hope it is visible, Madhu.
Yes, sir.
Okay. So the disclosure, arbitrator, he must make it before accepting any appointment. Okay. So challenging the arbitrator. If one of the parties, they are aware of it, then they can challenge to the arbitrator only. But only for the obvious reasons, not for any whimsical reason. Okay. What is the reason? They cannot simply say that the arbitrator is biased. The apprehension of bias, it must be judged from a healthy, reasonable, and average point of view, not on mere apprehension. Okay. There should be a strong grounds of bias. There shouldn't be any vague suspicions of whimsical, capricious, and unreasonable people are not our standard to regulate our vision. That is what the court said. Okay. Now, when the when the arbitrator is challenged, and if the challenge is successful, then his mandate will be terminated. Okay. Also, there are grounds when the arbitrator's mandate means arbitrator's power will be terminated, mainly on 2 circumstances. The first circumstance is de jure or de facto. De jure means by law. Okay, by law means it is non-compliance with the arbitration clause. If his appointment is in non-compliance with the arbitration clause, or if he is having any conflict of interest, which is identified in the law. Okay. So because the law, it clearly identifies what are the conflict of interest situations. So these are the de jure reasons. And what is the de facto? Factually, he is not eligible. he doesn't have the necessary qualifications. Then, also he may not be having sound health. He may not have sound mind. That is also another reason. So these are the grounds which will make him unable to perform his functions. Then his mandate, his power will be terminated. And then if he fails to act without undue delay, this I have mentioned. Almost all the jurisdictions, they fix the timeline for the arbitration proceedings. In UAE, even though the law, arbitration law, doesn't specify the timeline for the conductance of arbitration, the arbitration rules, they specify the timeline. The basic difference between arbitration in UAE and arbitration in India is, in UAE, you can say 99% the arbitrations are institutional arbitrations. That is conducted by the institutions such as DIAC, ADGM, etc. They have well-defined rules and that specify the very strict timelines. Once the arbitration proceedings are over, then the arbitrator is left with 1 or 2 months only to draft his award. Okay, and that is a very mandatory timeline. Suppose if he fails to act within the timeline, then his mandate, his power will be terminated by default. Okay, so therefore the arbitrator, he must know when his mandate or power will be terminated. Now we will see, when the parties, they are aware that there is some issue with the appointment of arbitrator, then they have to approach to the arbitrator only. They cannot go to the court. That is the uniqueness of arbitration process. Arbitrator is the judge for his jurisdiction also. Okay, so arbitrator may rule on its own jurisdiction, including the respect to the existence of validity of the arbitration agreement. Even if there is any gray area regarding the arbitration agreement, some of the arbitration agreement, they may not be certain in nature. There may be some ambiguous terms in the arbitration agreement. That can be only adjudicated by the arbitrator only, not by the court. Okay. Okay, suppose if a party, he finds that the arbitrator has been appointed not in compliance with the arbitration clause or arbitration agreement, and he approaches the arbitrator. Mr. Arbitrator, you are de jure or de facto not eligible to conduct this arbitration. The arbitrator, he must either accept the challenge or reject the challenge. If he accepts the challenge, what will happen? He will continue with the arbitration proceedings and he will make the award also. Okay. So in this circumstance, the next challenge will be along with the challenging of the arbitration award. Okay. You have to note this point. The challenging of the arbitrator's appointment will be first raised with the arbitrator only. And the arbitrator, he himself, he may sometimes accept the challenge. He will say, no, I am not as per what you are saying. My appointment is in compliance with the arbitration clause. Then what he will do, he will continue with the arbitration proceeding. He will issue the arbitration award. So now the parties, they have the chance, they have the choice only at the time of challenging the award. They can challenge the award, saying that the arbitrator's appointment itself is non-compliance. Therefore, the award given by him also is not existing under the law. So that is the choice they have. Suppose, on the other hand, if they accept the plea, okay, if they say that, yes, Mr. Counsel, whatever you are saying is correct. There are some conflict of interest. So what will happen? He will quit. Okay. So it marks a significant departure from the ancestral model law, which contemplates recourse to a court from a decision of the arbitral tribunal, rejecting a challenge to its jurisdiction. Okay. And now we will see what is the jurisdiction of the arbitrator. Jurisdiction means power to adjudicate a dispute. That is called a jurisdiction. Okay. So how he derives his power? He derives his power from the arbitration clause. Arbitration clause, next time when you look at your contract, you read word by word. That will set the boundary of adjudication. In certain contracts, they will exclude certain disputes. They will explicitly say that X or Y disputes cannot be adjudicated by arbitrator. So therefore, the arbitrator, he must stay away. If somebody approaches himself to be appointed as an arbitrator, he must check the arbitration clause. And he must say, Mr. Counsel, I do not have the jurisdiction. The arbitrator, whoever it is, whether it is me or any arbitrator, he doesn't have the jurisdiction. So therefore, he derives it from the arbitration clause, which is existing in the contract. Suppose if the if the contract doesn't have arbitration clause, then the parties, they can create their own arbitration agreement, separate agreement. So now the arbitrator, he must check this arbitration agreement, whether it gives him power to adjudicate the disputes in front of him. And what is the boundary of adjudication? Whether he can award any interest or not, whether he can award post-award interest or not, what is the threshold of the interest, etc., etc. What are the types of disputes he can adjudicate? So therefore, the arbitration agreement, that should be drafted very, very carefully. Okay, that my colleague, she will explain in the next session. Arbitration clause may not be signed, but must be stamped. It is just for your information. So these are the sources of jurisdiction of the arbitrator. Okay, now in the international arbitration, how the arbitrator is getting appointed. In the case of international arbitration, appointment of sole or third arbitrator in an international commercial arbitration, Supreme Court may appoint an arbitrator of a nationality other than the nationalities of the parties. Okay, where the parties belong to different nationalities. You know the definition of international arbitration. It should be of two different nationalities, the parties. Then only it is called international arbitration. Therefore, the court or the institution, they will appoint a neutral arbitrator. Okay. So then only the matter of bias, it won't be there. Principles of natural justice will be in its true spirit. Now, in the appointment of arbitrator, what are the applicable procedural rules? The acceptance of the rules is a party autonomy area. The Act, Arbitration Act, it recognizes the right of the parties to the arbitration to agree on the procedural rules. If they fail to decide on the procedure, then the arbitrator or arbitral tribunal, they can decide the arbitration rules. When they are framing the arbitration rules, they are not bound to follow the procedures being followed in the court of the respective country, because there is a clear demarcation between the court proceedings and the arbitration proceedings. If you look at the court proceedings, they are bound by rigid rules. If you look at India, they have, for civil cases, they call it as CPC, Civil Procedure Code. In UAE, it is Civil Code is there. UAE Civil Code is there. Okay. It stipulates very rigid rules for conducting the court cases. On the contrary, arbitration procedures, they are not bound by such rigid rules being followed in the court proceedings. Okay. So here it is to the discretion of the arbitrator. He can decide the rules. And disclosure, I have mentioned, I have shown you my disclosure. So these are the points for the disclosure, name, contact details, prior experience, number of ongoing arbitrations. Is there any conflict? Circumstances which are likely to affect your ability to devote sufficient time. All these things we must disclose. Number of arbitrators. Okay, so this is also party autonomy area. Parties, they can decide how many number of arbitrators, depending upon the volume of the dispute, complexity of the dispute. However, there shouldn't be even number. It will be odd number only. Multiples of, either it should be one, which is called a solo arbitrator, or 3 arbitrator, or sometimes 5 arbitrator. If you go to the permanent court of arbitration, which we have seen in the first session, there even you have 7 arbitrators in the conflict inter-country disputes. Okay. Failing any determination by the parties, the arbitral tribunal shall consist of a sole arbitrator in case of domestic arbitration. But if it is in case of international arbitration, if the contract clause, if the arbitration clause is silent, then it is 3 arbitrators. The arbitration clause, it can have named person as the arbitrator. If there is a name specified, then the parties, they must go for it. Okay, now the interesting part, arbitrator's fee. How the arbitrator's fee is set. Okay, there are 2 types of determination of arbitrator's fee. The first one, it is called ad valorem. The second one is called time spent methods. Okay, so we will see one by one. Ad valorem, it is Latin word. It depends upon the amount in the dispute. It's nothing but your claim value. It is calculated as a percentage of the claim value. A regressive fee scale will apply. It doesn't mean that if the dispute value is, say, $100 million, then you will get X percentage of 100 million. No. There is a fixed upscale in this method. Okay. So this is called ad valorem. Based on the dispute amount, the arbitrator will be paid X or Y percentage. Normally, the arbitration institutions, they will be having a calculation table. Okay. Otherwise, the arbitration tribunal, they will be having tribunal secretaries. They will determine the arbitrator's fee based on the dispute value. So that comes under the ad valorem method. The next method is time spent method. It is nothing but how many hours they are spending, hourly rate. Okay. So there are certain jurisdictions, they allow hourly rate for the arbitrators. So these are the different institutions which follow both the methods. So ICC, International Chamber of Commerce, CIATAC, that is China, SEC, Stockholm Chamber of Commerce, CRCACA, this is from Egypt, and CCJA, this is from China. They follow ad valorem. For that matter, most of the ad hoc arbitrations and most of the institutions, they follow ad valorem only. There are specialized institutions such as ICSID. ICSID, they adjudicate the investment disputes between the nations. LCAA, DAFC, LCAA. So these are the few institutions. They decide the fee based on the time spent method. There are certain institutions such as Hong Kong International Arbitration Center, Singapore International Arbitration Center, Taiwan International Arbitration Center. They adopt both the methods. And then expenses during the arbitration. In addition to the fee, arbitrator is allowed expenses also, on reimbursement method. How they are calculated? There are two methods again, reimbursement method and per diem method. Reimbursement method is actual expenses. He is expected to submit his expenses statement. Per diem means fixed amount. They agree. Per day, this much, irrespective of whether he spends or not. Okay, that includes his expenses for accommodation, etc., etc. And the arbitrator, what he will do, he will get an advance on the cost agreed in the previous slide. He will retain with him. He will maintain a running account with the help of tribunal secretary. Okay, tribunal secretary is nothing but secondment to the arbitrator. Sometimes they perform equal duties of the arbitrator. Okay, so you must be aware that tribunal secretary is the integral part of the arbitration process. My colleague Madhumitra, she has acted as tribunal secretary in many cases. Okay, just for your information, arbitration is not only about the arbitrator. Tribunal secretary is also an important role. Lien, my colleague already mentioned about lien. It is just to retain the award until he is paid, the arbitrator is paid. Having said that, we may repeat certain concepts time and again with the objective that it should register in your mind. Okay, because these are important concepts in the international arbitration. Then arbitrator's immunity also, she mentioned. In UAE and Middle East, it is incrimination. If the arbitrator is found to act against good faith, then they will be imprisoned. Whereas in India, they are provided immunity. Okay, even though UAE it is having incrimination by law, but so far I think no one has been imprisoned. Okay, and then IBA rules, I think she has run through in detail. So it is having the different grounds that decides the conflict of interest. There are basically 3 color-coded grounds, like waivable red list and a non-waivable red list, and then waivable, green list. So this non-waivable red list, by name it says, if there is some conflict, then the arbitrator, he must reject his appointment. He must not accept his appointment. These are certain grounds. Arbitrator is a manager, director, or member of the supervisory board or has a similar controlling influence in one of the parties, this is a non-waivable ground. Okay, he must not accept any appointment. Arbitrator has a significant financial interest in one of the parties. He may be a partner in one of the party. Then he shouldn't accept a case from them. Arbitrator regularly advises the appointing party, then also he should not appoint. He should not accept the appointment. So there are waivable red list. So these are the grounds of waivable red list. Okay, like relationship of the parties to the dispute. Maybe 3 years ago he did something. Then there are waivable red list. He must declare that to the parties, and the parties they should right, fine. It is the relationship was long ago, so therefore the arbitrator he can accept the appointment. And then orange list. Orange list means he must declare it and accepted by the parties. Then he can accept the appointment. Okay, so this is an example. Arbitrator has within the past 3 years served as the counsel for one of the parties or an affiliate of one of the parties. Then he must declare in the disclosure, and the parties they must say, okay, fine, we agree, then he can be appointed. Then the second one, arbitrator has within the past 3 years served as counsel against one of the parties, or an affiliate of one of the parties. Then also he must declare, okay, I acted against this person in the last 3 years. Then the parties they should say, okay, fine. Then he can get the appointment. So these are all orange list. Then there are green list. This green list, he need not make any disclosure also. Okay, what are they? Arbitrator has previously published a general opinion, only general opinion. Then it is not, there is no need to disclose about this. Then arbitrator's law firm has acted against one of the parties or an affiliate of one of the parties in an unrelated matter without the involvement of the arbitrator. Then it comes under green list. Currently, a firm in association or in alliance of the arbitrator's law firm, but which doesn't share fees or other revenues with the arbitrator's law firm. So this is another green list. Okay. So such ground they need not even disclose. They can accept the appointment. And waiver of rights. We have seen the conflict of interest or the de jure facts, which makes the arbitrator's appointment as ineligible. But the parties, they must act quickly, within a stipulated time. If they fail to act, then they waive their right of objection. So that is what this judgment says. Rail India Technical and Economic Services Limited versus Ravi Concession Bangalore. So in this case, what happened? The party who is challenging, he was sleeping for so many years, and then he approached the court. And the court, they rejected his appeal. What they said? They failed to object the appointment of the arbitrator within the time frame. Okay. And unilateral appointment. It is a very, very important concept, the appointment of arbitrator. Arbitrator appointment should be based on the consent of the parties. Both the parties, they should agree the appointment of arbitrator. Otherwise, his appointment will be non-existing under the law. Okay, there is a very famous judgments, Perkins Eastman Architects versus HSCC India. Okay, this is as far as India is concerned, but the same concept is applicable universally. Arbitrator cannot be accepted unilaterally. Unilaterally means by one party only. Then his appointment is invalid under the law. It is as simple as that. Okay. But there are certain exceptions to the unilateral appointment. How? If the project is very, very technically conflict in nature, technically complex in nature, then an unilateral appointment is permissible, because only certain arbitrators they can adjudicate that. Okay. Then qualifications of the arbitrator. That should be as per the arbitration agreement. If there is any deviation, then the appointment of arbitrator is invalid. And we have seen ad valorem. That means the arbitrator fee is as per the value of the dispute. But when there is a counterclaim, what happened? The counterclaim, it is having separate fee. That is what this judgment says, NTPC versus Hopkins. Arbitrator, whether he can award interest, yes, it depends upon the contract. What the contract stipulates, only that the arbitrator can do. And there is recent development. When there is a conflict of interest with the arbitrator and the dispute, suppose if the party they fail to raise the challenge during the arbitration proceeding, but they raise the challenge later on. Now the court says, yes, when there is a non-waivable red list kind of conflict of interest, then the parties, they can raise at any point of time. That is what this judgment says. P. Charan versus Gemini Industries and Imaging Limited. And I have mentioned not all the unilateral appointments are not invalid. Timeline that we have seen, there is a stipulated timeline. Arbitrator, they must be aware of it. Otherwise, what will happen? His mandate will be terminated without his knowledge. Okay. So therefore, they must be aware of what is the timeline and they must monitor that. Okay. So these are the things regarding arbitrator's appointment. If there is any questions, you kindly reserve it towards the end of the session. We will take up the questions. Now, Madhu, can you help me with the roles, please?
Yes, sir. Yes, we have started the polls. Please kindly answer.
Madhu, we may allow maybe few minutes for this because we have 4 questions.
Okay, sir, sure. Out of 10, 7 has answered, sir, so far.
Okay. Okay. So, yeah. Do you want to run through the questions?
Okay.
Or
So
you want me to do?
let me do it, sir.
Okay, please.
The arbitrator should be neutral and independent and need not to be a lawyer. The answer is both A and B. And second question is, if the arbitration clause is silent about number of arbitrators in the international arbitration, um, it will be either 1 or 3 or 2. I mean, these are the options. It can be either 1 or 3, but it could not be in even numbers. Depending upon the country, this number will vary. Next is ad valorem method of arbitrator fee calculation is based on the options of arbitrator's age, qualification, and claim value. Sorry, the answer is claim value. Lien of an arbitral award means retaining the award, attaching the property, withdrawal of an award. The answer is retaining the award. Yes.
Thank you, Madhu.